right, I've got Councillor Felicity Ford, who's a commissioner as well. We've got Alan Watson, who's an independent commissioner. So we're dealing with transfer. We've got Sharon Dines, Malcolm Hunt. Hi, Malcolm, can you hear us?
Hear you well, thank you.
Thank you very much. Rebecca, is it? Yes. Whoever wants to start. We've read the submissions, obviously. We've read the evidence that's been sent in. You read the Section 42A report, so you're here to tell us what you would like.
And tēnā koutou katoa. My name is Rebecca Eng. I'm Technical Lead Environmental Policy in Transfire's Environment Group. As you noted, Mr. Chair, I'm joined by Ms. Sharon Dines, our expert planning witness, and Mr. Malcolm Hunt, who is our expert noise witness. Thank you for accommodating Mr. Hunt to appear remotely today due to other commitments. He wasn't able to join us. And in relation to this hearing, the topics outstanding in terms of and that have been addressed in evidence, as you know, relate to earthworks and noise. And earthworks specifically in terms of how earthworks are managed in relation to around the national grid. So if the panel is agreeable, we thought that we would start with noise, so that Mr. Hunt can depart on conclusion of giving his summary and attending to any questions, and then we'll follow with earthworks. And I'll pass over to Ms. Dines at that time. So if the panel's agreeable to that approach from here,
you've got no problem
pass over to Mr. Hunt to give his summary.
Just so you're aware, Mr. Hunt, Mr. Ibbotson sitting here as well.
Thank you. Yeah, so my name is Malcolm Hunt. I've got those qualifications and experience set out in my evidence, and I'd like to take them as read. And just by way of preliminary, I will talk to my evidence rather than read the whole lot out. You might be pleased to know. And the issue is relatively concise, but there are sort of several aspects of it that I perhaps needed to explain to justify the support of Transpower's submission point. So paragraph 15, I've sort of summarised the position there, that Transpower submission point at 454104 sought to increase the nighttime noise limit in the district plan by 5 decibels, and as summarised there, it wasn't accepted. It was rejected by the council's Section 42A report. I summarise at the end of that paragraph that the council's plan, and my take on it, would be difficult to provide the relief sought by Transpower to increase the 40 nighttime LEQ limit to 45 without causing district-wide changes to the nighttime noise limit that would apply across all zones and would apply to all permitted activities. And I would have to sort of agree that the interpretation of what Transpower was asking for would have caused changes across the whole noise limit for nighttime noise limit for the district, and would have applied to all permitted activities. And we've, upon advice and discussions around it, we've refined that approach now, and I'll get to the recommendations shortly, but just going through my evidence in summary, the 45 limit was sought across a whole lot of zones there, and I list in paragraph 18 all of those different zones, and it was a rather comprehensive request. And so this evidence sets out that the nighttime noise effects within sensitive receiver environments will be adequately protected according to the relevant standards and guidelines in cases where a 45 LEQ nighttime limit is set. My evidence explains how 45 is adopted widely within the operative Far North District Plan, which, as far as I'm aware, has to date provided adequate nighttime noise protection. The evidence I present here also sets out how the relevant New Zealand standards and international guidelines that support a 45 LEQ nighttime noise limit will adequately protect amenity and health within sensitive receiver environments, which also includes an adequate level of sleep protection. Paragraphs 20 through 25 just talks about typical substation noise levels. Figure 1 there, I've taken an extract out of a recent report where noise levels from a typical rural substation are plotted in terms of noise contours, and the contours represent sound levels, equal sound level lines, and I've plotted there the location of the 55, 45, 40 and 35 decibel contours. And it shows there that the 45 is achieved roughly at distances between about 50 and 100 metres from the substation boundary, whereas typically 40 decibels is achieved at a far greater distance of something like 200 to 300 metres. And it's clear that setting a nighttime noise standard of 45 dB will significantly reduce the land area within which sort of an unreasonable noise finding could be arrived at when assessment is based on whether or not the permitted activity nighttime noise standard is achieved. And it's in my experience that council officers commonly base their assessment of reasonableness on whether or not the permitted activity nighttime noise standard is achieved. And I'd just like to pause there for a moment, because there's a couple of key points here that at the moment Transpower does not have designated substation sites in the Far North District, but that could easily change, and that's probably a matter for other people to discuss. But under a designation, of course, the permitted activity noise standard doesn't directly apply to the activities of Transpower, but the point I'm making here is that should there be a complaint or being investigated around unreasonable nighttime noise, the sort of first port of call for council's investigating officer regarding reasonableness is, would the permitted activity nighttime noise standard be breached or not? So that's a strong sort of driver for this increasing for substations a nighttime noise limit from 40 to 45. A sort of corollary of what I'm discussing at the moment is that substations, you might be aware, often commonly emit at least a hum, and it's due to transformer resonances, and it's not unusual and is a common feature of substations. And it is possible, indeed likely in some cases, that when assessing noise from substations under the relevant New Zealand standards, which are adopted within the proposed district plan, that a 5 decibel penalty would apply because of the sound, a hum, being deemed to be a special audible characteristic, and under the recommendations of the New Zealand standard NZS 6802, the assessment officer is entitled to penalise that sound by 5 decibels, and that's relatively widely accepted. So what that means in real terms is that where the sound under investigation includes an audible tone, the relevant noise contours in figure 1, it's the 40 dB contour for situations where the nighttime noise standard might be 45 as requested when this audible tone is present. And similarly, the 35 dB noise contour is a relevant noise contour should a 40 dB noise limit apply during the night time with an audible tone present. So although we are talking 40 and 45, for substation noise, typically under the assessment procedures of the relevant standard, you're probably more often than not talking about either 35 or 40 due to that 5 decibel penalty. Paras sort of 29 through 31 to 34, I've just described in there how the operative plan states in almost all cases that the nighttime noise limit would be 45 decibels under the operative plan. This I need to explain, and as your noise expert has set out in the officer's report, there is a change in noise unit from L10 to the more recently adopted LEQ unit for noise as a noise metric. Although the two are for typical sounds in the urban environment, such as traffic passing a receiving point or noise from factories or whatever, it is quite true that there is an appreciable, small but appreciable difference between LEQ and L10. However, in the case of substation noise, which is more or less constant, at least within any given 15-minute period, and therefore we find by measurements that the LEQ and the L10 are more or less equivalent. So in my evidence today, I'm stating that the change in unit has very little impact on quantifying noise from substations, and we are really talking about this 40 and 45 limit as if it were L10 or LEQ, and there's no real difference there. So moving through, I've set out how under the relevant noise guidelines, so this is both World Health and the relevant guidance within New Zealand standards, how a 45 nighttime limit on the outside of habitable rooms, bedrooms, etc. is an acceptable limit for nighttime noise, including when the windows are open. It is true that many district plans have set lower limits, and as they're entitled to under the New Zealand standards and under the normal kind of democratic process of setting district plan limits that suit the needs of the district. So we're not saying it's in any way wrong or incorrect to set the 40 dB nighttime limit. We're just, my position is that it will cause difficulties for Transpower should substations be developed, and is at the end of the day isn't necessary in order to protect from any potential adverse health or amenity effects. I have really want to just move on now to my overall assessment and the recommendations to achieve what Transpower are now seeking in the proposed district plan. So I just set out at 46 there how the relevant guidelines do allow for up to 45 at night, and I say there at para 47 how I don't see it as necessary to adjust the nighttime noise limit by 5 decibels increase. I don't see it as necessary to apply to all permitted activities across all zones, which, you know, I agree is one interpretation of the Transpower request. Instead, I recommend the revised noise limit apply only to substation sites. And at 48 there, I just reiterated the planner's concerns about district-wide changes, which was, you know, one possible valid interpretation of what Transpower originally submitted. So I've set out how in attachment 1, how the noise rules could be just slightly adjusted to accommodate Transpower's request. And I'll just turn to that now because I'd like to sort of encourage the idea that it doesn't change the wording of the overall noise rule set out in Noise S1 to any great degree. There are already under Noise S1C a 45 dB noise limit applying to noise generated in the hospital or heavy industry zones or by mineral extraction overlays or within mineral extraction overlays. And so what I'm seeking to do there for those relevant receiving zones to just include substations within those list of noise emission sites. There's a second group of receiving zones that are in a group noise S1D to G, actually D to F. And in this group of receiving zones, there wasn't an equivalent 45 nighttime noise limit that we could have adjusted to include substations. So we've had to draft a new provision called G, which applies just to substations, and it adopts the normal daytime noise limit, and it has got the 45 night, and then that's basically it. There's just there's other receiving, so there's other provisions of the noise rules which aren't required to be adjusted. Oh, there is one. The last one is actually Noise S1J, which is again that category of noise from hospitals, heavy industry zones or mineral extraction overlays, and we've added in the substation activities to that group, and because that group of activities does have the 45 nighttime limit, which would satisfy Transpower's request. There's just one passing note, which isn't directly relevant to Transpower's request, but it is noted there that with respect to noise S1F, there isn't a nighttime noise limit, but I noted there was one in the notified version of the plan, so I'm predicting it's probably some kind of typo. And but however, my investigation shows that under the notified version of the proposed plan, that would normally have had a 40 dB nighttime limit, and thus meaning that we've added in this new noise S1G because there were no nighttime rules within that group of receiving zones that had the 45 that we're seeking. So in summary, the changes are quite small. I think there's a reasonable need for what we're talking about, and at the end of the day, 45 at night in normal circumstances, not unreasonable or excessive, and will be adequate to protect against adverse effects of noise from substations at night. So yeah, I'm happy to answer any questions.
Thank you very much, Mr. Hull. I've just got one question. With the operative district plan limits of 45, do you deal with complaints for Transpower up here?
Yes, we do. I often do, yeah.
Have you had any, what I call justified complaints or issues with the limited 45?
No, I can't think of one example. A couple of things are that due to some, unfortunate historical arrangements, there are sometimes dwellings within, let's say, 50, 100 metres, and some residences do receive that sort of noise at night time under normal operating conditions and without complaint. And then there are other situations where people living further away and receive a lower level of noise do complain, and that's probably more a function of variable sensitivity to noise, particularly at night time when even a low level of sound can be heard, audible, and probably due to a lack of other activity in the area, and those sounds can be disturbing to the extent that some people do complain, but that's not unusual. I mean, we've spent a lot of time and effort investigating noise from overhead electrical, high voltage lines, and that Transpower have strung up and down the country, and some of them have generated complaints, and the received sound levels can be very low, 30 to 35 decibels, and still generate complaints. So, we have to deal with complaints arising under a range of circumstances, but in summary, 45 decibels is not sound received from substations at 45 decibels has not been generating significant complaints in my experience.
Thank you very much. No, that's pretty clear. Thanks.
Thank you.
Question? I'll just ask Mr. Ibbotson if he's got any points of clarification or if he wants to comment on anything. You don't have to.
I know, I don't. I'm tempted to.
Don't tempt.
I broadly understand. I think the evidence is clear. I suppose the question is that I have. There might be a situation. It seems that the rule is being proposed to cover off perhaps a new Transpower substation that might be developed at some point. We don't know where it might be, but it seems to me that perhaps the question for the planet, that's the intention of this. It might
both existing and planned, isn't it?
Yeah, so there are no existing substations at Transpower.
No designated substation. Sorry.
No, not currently. It
They've got
is
no
so local action that was not existing.
So there are existing substations that are that Top Energy have, and Transpower, as I understand, do not have any. But Transpower's concern might be that they might want to develop a future substation that might need to be subject to a more lenient limit for reasons of practicality or compliance. I guess the question I have is that whilst Mr. Hunt's statement that 45 decibels is reasonable and appropriate, in some rural environments where the background and ambient noise is far lower, a noise level of 40 decibels would be better. 45 might be acceptable. 40 decibels would be better. I guess my question is, would a lower threshold, would a lower limit that applied to standards, i.e. the zone standards that exist, potentially drive better outcome for those people? Because there would be more emphasis on choosing the best practical option, choosing a quieter transformer than there might be otherwise if the zone limit was more.
Understood. I understand the question. Well, I think my first overall comment would be, should Transpower establish designated substation sites, they would be subject to a planning process. Noise as an effect would be very much included in the assessment of effects and be considered by council at the time. And I guess if the situation, for example, isolated rural area with a very low background sound, if that justified the 40 nighttime noise limit, we could address that at the time, and yes, it might end up driving additional mitigation and selection of a best practical option, which is mitigates more noise more than the average substation. But I feel those matters, if they're relevant, would be site specific and be dealt with at the time of the designation process.
Thank you. No, that's very clear. Thank you very much, Mr. Hunt. If you're happy for to leave, you can leave. More questions. Thanks very much.
Yep, thank you. Thank you for your time
today.
I'll leave now. Thank you.
It's Diane, is it?
Yes. So the other outstanding concern was in relation to earthworks. Yes, so you know me, I've been here before. But the other outstanding matter for Transpower was in relation to earthworks. And there were two issues that became apparent to us as we were preparing evidence. The first one was in relation to the policy associated with earthworks, where Transpower sought a change to better give effect to policy 10 of the NPSET, the National Policy Statement for Electricity Transmission. And I think Mr. Wyeth proposed a change, which I've set out there in paragraph 13 of my evidence. And in my opinion, that doesn't necessarily, I think, go far enough to give effect to policy 10, because it only deals with the operation of infrastructure, whereas policy 10 in the NPSET deals with operation, maintenance, upgrading, development of the electricity transmission network. And in particular, it requires that that is not to be compromised, which is quite a strong directive in the national policy statements or in a national policy framework. So I proposed a solution. Well, we have a solution in relation to the overall policy that we have proposed in the infrastructure chapter to address the national policy statement for electricity transmission and giving effect to that. And I've given you sort of two options. So we could either have something in this chapter that refers back to that. We're in that sort of twilight zone a little bit where we haven't resolved those issues in the infrastructure chapter yet. So we're all kind of flying a little bit blind as to where we're all going to land. But if we resolve it that way, then we can have a policy in the infrastructure chapter that actually deals with earthworks, and we have that proposed in Transpower's submission, and there may be some tweaks to that. Or alternatively, we could take part of that policy and bring it into the earthworks chapter. And so that's set out in my evidence.
Suppose we could, infrastructure not dealt with until April next year, is it?
Helpfully, Mr. Chair, Mr. Wyeth is also handling the infrastructure.
Oh, okay.
He is available in online questions as well.
All right.
Yeah, so that's in March, April next year, and we've got, we're talking with council and the other experts and the other submitters on that chapter about doing some work in advance of that hearing to make your lives easier.
Make our job easier.
Yeah, so it will be resolved in the fullness of time, but we sort of felt we needed to sort of state the case here as well, so that it was clear. And then in the course of just tidying that up, we also picked up an issue which was an error on our part, both mine and Transpower's. Ms. Ian was actually on maternity leave at the time, so she doesn't she
Don't take any responsibility.
she doesn't have any responsibility, but we picked up a couple of errors in what's now Rule 2, where so that rule is designed again to give effect to policy 10, supported by that policy 10 in the NPS, supported by that policy in the district plan. But we realised that Transpower doesn't actually have any 220 kV transformers, lines in the district, or any 66 kV transmission lines either. So we just felt it would probably be more correct to delete those two matters. And we proposed that in evidence, and I have another copy of that here because we brought it up with Top Energy as well, and I appreciate you probably spoke to them about it, or Mr. Baden spoke to it on Tuesday.
They don't want a deletion of the 66.
They don't want the deletion.
Have you had agreement on that? Because he wasn't sure whether you were going to get an agreement.
I guess the rule is designed to give effect to the policy 10 of the NPSET, and the policy 10 in the NPSET is specific to the national grid. So in a purist sense, I think it probably should be deleted, but in reality, it's kind of like, I don't think it really matters. And Missy might have a view on that as well, but if they want it kept, I don't think,
His evidence the other day was that Top Energy may, within life of the district plan, have a 66 kV.
Yes.
He's not going to have a 220 with a 66. That was his, I think, evidence wasn't significant.
so I'm not
You're happy either
too
way.
concerned by the, it's not something I'm going to die in the ditch on, so. So that was it really, just those 10 minor points. Happy to take questions.
So you're pretty much in agreement with what Mr. Wyeth is saying?
Yeah, except for those 2 minor points, yes. Yeah, no, we're happy with, I think the streamlining of the rules is very good. Makes it much more simple for everybody.
So we'll hear back from Mr. Wyatt later on today, and then in 4 weeks' time, then we'll get a written reply. He will go on the council's website and you get notified there, so you can see what Mr. Wyatt has said to us.
Yes, very good.
No, I'm just remembering back the question of Top Energy was about the word upgrade, but that be potentially addressing capture as well, which is probably common to Transpower as well in terms of networks. Yeah, I think it's been addressed in the infrastructure chapter. Let's get clarity from staff.
Yes, so those, I think there was, and Mr. Wyeth may be able to speak to it more directly than I can, but my reflection is that there are matters or being considered a definition of upgrade that is bespoke to actually significant infrastructure. Mr. Wyeth, can you confirm that?
Yeah, I think because the definition, there's a submission from Top Energy on requesting a definition of upgrade, which has been allocated to the interpretation hearing right at the end. And I think what was agreed the other day was that we would allocate that definition to the infrastructure chapter because it primarily almost exclusively relates to infrastructure. So I was going to address that just at a high level in my reply for this hearing, but noting the recommended to defer it to the infrastructure chapter. I think, was that the question?
Yes, just noting that there'll be comment.
Yes, I can't off the top of my head recall whether Transpower made a submission on that point or a further submission, but we are going to be involved in that process on the infrastructure chapter anyway, so we can address it.
Yep.
I don't have any qualms about it being moved.
To have this, either you or Mr. Wyatt got any points of clarification, otherwise it's fairly straightforward to the panel, I think.
Not me, Gerard.
Mr. Wyatt,
No.
anything? No?
Nothing for me, no, just useful to hear the discussion.
Right, we'll continue the talks to try and make our job easier for you.
Yes.
Thank you.
You
And we will see you at the trap. Are we doing the infrastructure? I think we are. Yeah, I think so. But anyway, thanks very much for your evidence. Unless you've got anything else.
No,
Okay.
that's all. Thank you.
Rest of the day. Now we go to Kiwi Rail Holdings Limited, and I've got Kristen Gunnell. You online?
Thank you, sir. Yes, sir. Thank you. Can you hear me?
I
Okay?
can now, yeah. We've got Matthew Pets or Pets, is it?
Yes, yeah. So I'll just briefly introduce the team, and firstly, we'd like to thank you on behalf of KiwiRail for hearing us remotely. We really do appreciate it. We're sort of all scattered around the country, and it's much appreciated the ability to appear before you on screen. So tēnā koutou katoa. My name's Kristen Gunnell, and I'm a special counsel at Russell McVeigh, and I've been assisting KiwiRail with the legal aspects of the Far North plan review. As you noted, I'm here with Mr. Matthew Pates, who's a senior RMA advisor at KiwiRail, and he'll be able to give you some more information on the rail corridor within the Far North District. And then Dr. Stephen Charles, who I understand has already appeared before you this morning, and so needs no introduction. and Ms. Kath Hepplethwaite, who has been providing external planning assistance to KiwiRail. So I guess I did circulate legal submissions yesterday. I don't propose to read through them because I guess this is more a planning / technical matter for KiwiRail in terms of this plan. My understanding is the council officer was open to acoustic provisions sought by KiwiRail, but there was the question around the actual active or inactive nature of the rail corridor. And so Mr. Pates and Ms. Hepplethwaite will sort of talk you through the approach that KiwiRail is proposing, and sort of, the headline item is we would like a alert layer at the moment so that people are aware that they're near a rail corridor that could become operational, and then have plan provisions that can be triggered once those trains do start going along that rail corridor. So my role today was really just some introductory remarks, but very happy to take any legal questions that you have throughout the presentation while the others are speaking or afterwards. Otherwise, I was just going to hand over to Matthew to sort of briefly run you through the rail corridor in the district.
Just very quickly from our point of view, we have read the legal submissions that came in yesterday, so we have read them. The only legal question I've got, were you involved in the appeal mediation with Whangarei District Council and the other bodies regarding the rail corridor?
Our team was. I personally wasn't, but I'm certainly aware of those proceedings.
So what you proposing for Far North, is that very similar, exactly the same as what's in Whangarei District Plan, do you know?
I can come back to you on the differences. I expect there will be, because the Whangarei process, as you know, was mediated, and Dr. Charles was involved in both, so he might be able to give you more insight into any technical differences. But KiwiRail's standard provisions that they insert into submissions, I think will be slightly different, at least from the Whangarei, but I understand the substance would largely be the same. And Stephen, I don't know if you want to comment on that now, because I think you have more insight into any changes that were made as a result of that mediation.
Yeah, and obviously Mr. Robertson was involved as well. The substantive provisions would be the same. The key difference being that in Whangarei there's active corridors with lots of trains where the provisions apply now, whereas KiwiRail is now proposing for the Far North District that those provisions would only kick in when the lines become operational. For the Whangarei, the rail noise was modelled. So in every other district around the country, the rail noise has a fixed distance. In Whangarei was a bit of an outlier that they tried modelling through that mediation process we discussed. However, what the modelling showed is that the boundary fairly much went out to 100 metres where there was a busy line. So the modelling didn't provide any additional information. When I say it went out to 100 metres, the model contour actually went further than 100 metres, but everything was capped at 100 as a pragmatic compromise. But in terms of if controls were applied in the Far North and when the line became operational, then the basis of those controls is essentially the same as what was discussed in Whangarei.
Okay, thank you very much, Mr. Charles. So Mr. Gunnell, do you ask your staff your experts to please?
Thank you, sir. Yes, I'll ask Mr. Pates to briefly run through a summary of his evidence.
Good morning to you all. Kia ora. So I've just got some speaking notes that I'll try and run through fairly quickly. Good morning to you all. So my name is Matthew Pates. I'm a senior RMA advisor at KiwiRail. I'm based in Auckland. So in terms of just broadly speaking, obviously the railway network across this country is nationally significant, and across most of the regions of the country it's also regionally significant infrastructure asset. And there's obviously a lot of benefits to rail. I won't go into any details there, but it's important to the economy. And rail is also very effective in terms of generating fewer carbon emissions in terms of freight compared to heavy road freight traffic. The KiwiRail expects that demand for rail freight and passenger services will continue to grow across the country. And just as an example of ongoing government investment, the government just last week announced over $100 million in investment for the metro rail networks in Auckland and Wellington. Obviously, Auckland and Wellington are not the far north, but the point there is there's been a lot in the media around pulling back on railway investment, but the government still is actually investing in rail. The government has also invested in the recovery of lines in Northland after the 2023 events. So KiwiRail does still have very strong interests in the far north and Northland. And actually, we're just in the middle of preparing a resource consent application for some works in Oteria, just next to our railway yard there. Those works will assist with the regional council's flood recovery works. So, that's not related to the KiwiRail rail operations as such, but I guess it's just evidence of our ongoing commitment to the region. KiwiRail has one designated corridor which passes through the Far North District, which is the North Auckland line. As you will be aware, this line is not currently operational in the district. However, it is a valuable infrastructure asset. And our designation means, it could become operational quickly at any time in the future, and potentially within the life of the plan, if there was demand or need. Given the minimum 10-year life of this plan and the projected growth in rail, in general terms, it is really important for us to plan for the potential for the North Auckland line to become operational by including appropriate controls in the proposed plan to protect and provide for the operation of the rail network. And I think for us, this is a really important point. As you'll be aware, funding for infrastructure waxes and wanes depending on which government is in power. So there is quite a lot of uncertainty, but there's every chance that we could see a lift in investment intentions potentially in the not too distant future. And it's really important. We've got the designation there in a place. The key role of the designation is to kind of protect that corridor and allow the ability for those potential future plans to be realised. Just in terms of the proposed noise controls, Ms. Hebblethwaite will talk to those in more detail, but effectively there's a twofold solution in terms of what we're seeking. Firstly, an information-only rail noise and vibration alert layer. So this is not a rule as such, it's just an alert layer. This acts to put people on notice that the rail corridor is in proximity to their properties and that it could become operational in the future. And secondly, actual rules, controls requiring acoustic insulation. And what we're proposing here is that those rules will only be triggered if and when the North Auckland line becomes operational with regular rail services. So Ms. Hebblethwaite will talk further to this, but I guess we've tried to find a sort of a pragmatic solution there. Yes, the line's not operating at the moment, so it seems quite heavy-handed to have rules. So that we've got that trigger there that those rules would become effective if the line becomes operational in the future. Dr. Charles's evidence sets out the technical basis for why the proposed alert layer and acoustic insulation provisions should apply within 100 metres of the rail corridor. Overall, I consider it is appropriate and necessary to include these controls in the proposed plan to mitigate adverse effects in terms of noise and vibration on the most effective sites, and we consider the most effective sites to be sites within those distances that we've specified, and for those, or at least for the noise control to be triggered when the railway line becomes operational, as I stated before. That was all I was proposed to talk to today, and I'm happy to answer any questions that the panel may have.
Thank you very much. Question?
I just, hi, kia ora, kia ora koutou, Felicity Poitene. I wanted to ask, where is the rail? I've got some, and you've got your original submission here. If you describe it in words, because there's not like a map of the whole district. My understanding is that it goes from Whangarei and then north and then goes out to Opua, and then on these maps that are in your original submission, it goes out through Kaipuke and then through, I'm not sure where it ends, in the panel, but I don't think it goes north of Mangamoka, and I'm not sure where's the most northern point on the eastern or western side of the district.
Can you tell us roughly just where it goes in? The path?
Yes, I think that's generally summarised the route and the extent of the route. Yeah, to be honest with you, I am quite new to KiwiRail, so I'm still getting my head around the various operations. I'm just looking at a map now. Sorry, just one moment. I'll just have to increase the size of that a bit.
So just while you're finding that, my supplementary question for that is, our council, we have got a lot of cycle trails that we put on the old rail corridor. So that is why I asked that question. I wasn't sure when the council says road corridor, I'm not sure if that's within your designation, or essentially it's probably quite important for our district to know where you're proposing these rules and overlays for.
Are you there, Mr. Platt? Disappeared.
Yes, no, sorry, I was trying to have a look at the plan and.
Okay, that's right, that's right. No, you're all right.
I had to go close to the screen. Look, unless Kristen knows, it might be better to come back to you on the details of the line itself. I was just I was looking at a plan that.
What I suggest you do is maybe if you supply a copy of the plan, if you can, and maybe an explanation of where the rail corridor is that you want designation of the plan, the lines on. You can send that to AK, and then the officers can send on to us, and then the officers who are going to respond can also have a look at it.
Thank you, sir. We'll certainly provide that plan, but I guess, and I think Kath might be able to add to this, KiwiRail currently has a designation, and so to the extent that there's any cycle trails within that designation, that would be an agreement between the cycle trail provider and KiwiRail. But the key point is that the designation allows rail to become operational at any time. And my understanding, without knowing the specifics, is that any lease agreement that KiwiRail puts in place allows KiwiRail to terminate with a short period of notice, should they need it for operational rail. And so, if there was an economic case that rail was triggered in the district, then that would need to be worked out between the parties as to how those cycle trails were affected. Kath, I think I recall a conversation with you about this, and I just wonder if you have any additional detail you could provide here, or if it is something we check with the folks who have been involved in that specifically at KiwiRail, because Mr. Pates hasn't, doesn't have, I guess, what's the word? Personal knowledge of those particular arrangements. Kath?
Yes, thanks, Kristen, and good morning, everybody. I had a discussion with one of Matthew's colleagues before he commenced, Ms. Grillinton Hancock, who was involved in the original submissions. And just to be clear, the noise overlay and also the alert boundaries and the proposed operational rail rules, which I'll come to shortly, they apply relative to KiwiRail's designation, as Ms. Gunnell has pointed out. What we can do for you, which I have seen in, like Mr. Pates, I just don't have immediately at hand, is provide you with a map of where the rail lines are. And I'm sure if we ask nicely, we can, of KiwiRail's GIS team, we can point out for you which part of the designation is currently occupied by the cycle path, which runs from, as you'll all be aware, each coast of Northland. So we can provide that after the hearing. That'll give you a good pictorial layout. But if you want something immediate, the KiwiRail designations as they're shown on the proposed plan will give you an immediate view of that. If that helps the panel. Otherwise I will.
We'll take up the first offer. Thank you.
All right, we'll provide you a plan. Yes,
Thank you
absolutely
very
no
much.
problem. Thank you.
And any other question?
Yes, the question I had was, what does operational mean? And is that a train a day or is it a train a year? What does that mean?
I think
for the question,
Kath and Stephen are, oh, sorry, Matt, you go.
Oh, well, yes, I think Kath and Stephen addressed that matter, was what I was going to say. But I mean, operational, yeah, it's broad, isn't it? It could be just 1 or 2 services a day through to numerous services a day. So, but if the line's not operational, basically, or mothballed, it's not being used for any service. So.
Yeah, Kath, Ms. Hepplethwaite has provided a definition which we'd be happy to discuss. And I know from previous conversations with Dr. Charles that there is no kind of magic threshold where, you know, 3 trains is fine, but 4 is the provisions need to be triggered. So I will leave both of them to explain further where we've come to. And it, you know, it is kind of a spectrum of, you know, how many trains are these provisions kind of linked to. So yeah, well, I'll leave that to Dr. Charles and Kath.
I think Ms. Hepplethwaite covers it in her evidence anyway. Yeah. Yeah, action for a new definition.
Those are my.
Mr. Path, obviously you've just joined, so you may not know, but when we were driving north, Mr. Watson and I would come through Whangarei, you see all the works at Carmel Bypass on the rail. And then all along the most side of the rail there's new sleepers. Is that a continuation of your work on the try and make the North Auckland Ring line safer or usable? Do you not know yet?
Yeah, as I say, I've only been at QR 3 months, and there's a wide geography. There's been lots of emergency works in response to the storms from last year, and there's always ongoing maintenance works along the corridor throughout the country. So sorry, I couldn't say exactly what those works are, but.
Okay, it looks like a little more than just maintenance.
Anyway, thank you very much.
Sorry. I had a question. Mine is to the noise. To noise people.
Do you want to deal with it when we missed after Mr. Chow has given his evidence?
Yes.
In case he answers that. Who do you want to call next, Ms. Gunnell?
I'll now ask Dr. Charles to brief summary of his evidence.
Hello again.
Hello again, panel. As my evidence has been read, I really won't go into any detail, but happy to take questions in a minute. Just to sort of flag that as we had for road noise, the fundamental issues are the same, and the fact that you've got people building houses where they'll be subject to an adverse health effect, and there's a practical opportunity to address that for those new houses, and so it's the same for road and rail. But the niggly thing in this district compared to other districts where we've looked at these rules is the fact that there aren't actually any trains running, and so the complexities all relate around that sort of having a a holding pattern of an alert layer where you can build a house without doing anything, but you've got a flag that there's something you might like to think about, and then it flips to that second state when you do have operational rail. Just stepping back to one of the questions that came up about how many trains. So in the appendix to my evidence, I've gone through sort of rail noise levels, and I've sort of tentatively suggested, well, you know, when you get to say 6 freight trains a day, then the controls are definitely warranted. Controls over a lesser distance may be warranted at fewer trains, but I think in this instance it's likely to be self-regulating in terms of the fact that there'd have to be some investment to run freight trains on a regular basis again, and that for that investment to occur there'd have to be some kind of regular service. So it's likely to be that the volumes would then justify the noise controls when the operation starts. So I didn't have any other comments I wanted to draw to your attention, but more than happy to answer any questions.
Any questions for Mr. Childs first? We'll get it. Ask the question to you first.
So the question that I always ask in, noise and vibration, 100 meters, why 100 meters?
Yes.
Or train. Yeah, I guess or both.
So when I was talking to you earlier about the road noise, the 100 meters was a purely policy decision from NZTA that the effects extend further than 100 meters for the road noise. And NZTA said, okay, well, from a pragmatic point of view, we're only going to try and capture the worst ones. And so it was limited to 100 from a policy decision, not a technical basis from me. For rail, it actually ties more to the technical. If you look at the appendix to my evidence, there was some work done by Mr. Ibbetson's company originally, where they looked at noise levels for a number of rail lines. And if there's a couple of freight trains in an hour having to go past a location, you tend to end up with exposures that need mitigating out to about 100 meters. And when we did the modelling for Whangarei, we ended up with, again, we hit those sort of same distances. So the 100 meters for the noise for the rail, that's about where the effects occur out to. For the vibration, it's really variable. So with noise travelling through air, for a given train, the levels are fairly similar. The terrain might screen the noise, and it won't spread as far, but it's reasonably predictable. Vibration isn't. Vibration varies very much from different areas depending on ground conditions and any ground features. So with vibration in the appendix to my evidence, I've given measurements for rail vibration at a number of locations around the country. You tend to exceed criteria out to about 100 meters. Where KiwiRail's asked for controls, it's only asked for controls on a lesser distance, just as a kind of a pragmatic thing, acknowledging the fact there's a lot of variability there. But in terms of an alert layer, the 100 meters is a distance where typically you might find those vibration levels. So I think you're asking it's a very valid point. What's his magical number? So for the road, there was a policy element to arrive at a round number. For the rail, it's much more driven by the data that I've got appended to my evidence. So that's a reasonable basis for where the effects go to. Again, they do still go further, and KiwiRail has kind of limited how far they're asking for.
Mr. Ibbetson, do you want to comment on the same question, or do you can just say you agree with Mr. Child?
I think I provide a little context about the Whangarei plan, because you asked about that. That's reasonable, but I'm a little bit conscious of I don't fully know what I'm able to disclose, because I'm not quite sure of the legal privilege of mediation, that situation. But so I'll say what
the provisions that are in the plan will be public.
Oh, there's public, yes. And so I'll say what is public. So if you look at the Whangarei, the outcome of the Whangarei mediation, you'll see that there isn't a noise control boundary for rail north of Whangarei. It's only south and certainly south, Dr. Charles can possibly confirm this, but certainly south and possibly encompasses the future Marsden Rail link.
So when we, as I said, when we were driving through the other day, and you pass from Whangarei, Carmel bypass, there's a lot of works going on the left-hand side, and then further along, just as you get outside, there's all of the, as I said, sleepers on the side of the railway for kilometres.
Yes.
Whenever you see the line, so you're saying none of that line, say north of. Once you get out of Whangarei City, has got any overlays, anything?
North of there's a central station in Whangarei, which you might know. I think it's near Seminole Stadium.
Yeah.
And as I understand, and someone could possibly share a map if they were so inclined, but as I understand, the noise control overlay does not extend past that point. And that's there are trains that use the Northern Rail line. They run to Fonterra. They do freight shunts up to Fonterra, and they carry a couple of freight cars up. They drop them off, they fill them up with milk powder, and they bring them back. And so that, if you talk to Kiwi Rail or Fonterra, they'll tell you that happens there's about 6 movements a week typically. And they're quite small trains in terms of their length. So they're not really comparable to what might be required to, say, bring logs out of the forest, I don't think. A little bit outside my area of expertise there. The point is that line through the mediation, the result is that there is no noise control boundary that applies to that operative part of the rail. There is a vibration and noise alert layer that sits over that line, presumably, and I don't know the answer to this, but presumably that's to alert people to the fact that there's a rail nearby. But there aren't any controls that sit over that line. The reason I bring that up is because it sort of relates, I think, to the number of movements that might occur per week. Because certainly if you have a very busy freight line which operates many movements per day, then the noise level is higher. Whereas if you have a number of 6 freight shunts of a small line up to Fonterra, then within 1 hour you might actually get a similar level of noise, but over the week you obviously get a much lower level of noise, and arguably the effects of that would be lower. Dr. Charles just talked about the fact that a very small number of movements might not have the same effect as a large number. It seems logical. So hopefully that's useful context.
Yes, I wasn't sure about in the definition, they're looking to amend the definition for noise sensitive activities to include hospitals as well. That's on page. So I wasn't sure as well from the staff if that was a suggestion from the noise expert or whom, or if staff were comfortable with including that activity as a noise sensitive activity. So why or why not?
Yeah, can I just ask, will Miss Applewhite be covering that?
Yes.
What we'll do, we'll come back to the staff that we've heard from her in case she deals with that issue. Anything else?
I think from a noise effects point of view, Mr. Ibbotson and I probably very closely aligned on what's a noise sensitive activity that needs protection, and in terms of how the definitions and so forth in the plan capture all those things, that's a matter for the planners to sort out the wording for.
And we've got no more questions, Mr. Childs. Thank you very much. We're now going to go to this Applewhite, is it?
Yes, good morning panel and other hearing attendees. Thank you for hearing remotely today from us. I thought, as it appears you will have reviewed my evidence already, that it might be most helpful if I go to my attachment A, which is on page 15, PDF page 15, so I'm not sure which paper number that will be, and just walk you through the amendments which I have suggested. I will say at the outset that there is probably three topics covered in my evidence. There's noise, which has been the focus of discussion so far. There is signage, of which there is one outstanding point, And then temporary activities, which I'm in complete agreement with the 42A officer's recommendation on. I'll just quickly cover off the signage issue. You'll note that in my evidence, I have requested a change to policy 3 of the sign provisions that relates to level crossing and visibility of signage at level crossing or proximity. That should be pretty straightforward, so I won't dwell on that further. I just didn't want that to be overlooked in the broader noise discussion. So unless I'm happy to answer questions on those, of course, but otherwise, I think probably the thing of most interest will be the amendments and attachment A to my evidence, if you have those at hand.
Yes, we've got them here, gone through.
Excellent. Thank you. I'll start with the topic which we've just discussed, which is noise sensitive activities. You'll note there that in the evidence, in my evidence, I have reviewed QRL's submission also relative to the notified plan and the council recommendations. The change I've recommended there is that hospitals should be included. The issue is a little bit more complex than just changing the definition, however, because the definition is, not terrible as it sits at the moment, but how the definition sits amongst the rules. And if I could just quickly skip down the page a little bit to my amendments to noise S5, you'll see there in the very first line in red that I have proposed to strike out the word habitable room. The reason for that is habitable rooms is a defined term, and if you apply the rules only to habitable rooms, it will not capture all of the noise sensitive activities. If you like, habitable rooms is a subset of noise sensitive activities. So in that regard, I have made a number of amendments through S5 to endeavour to ensure that noise sensitive activities, the defined term, as I have proposed to amend it, are the activities which are captured by Rule S5, and that is not limited by the use of the term habitable room. I do appreciate that S5 has got a lot of suggested edits to it, and I would offer, if it was of interest to the council or the panel, that I could assist in any expert caucusing if it would help if the technical experts got together. Either I'm sure Dr. Charles would be available as well with regards to any acoustic expert conferencing, if you like, which might simplify things and may or may not result in some agreed suggested amendments for consideration of the panel. So leaving the noise sensitive activity definition, I think the next thing that's been of interest there is operational rail line. As Mr. Pates and Dr. Charles have described, we've endeavoured to construct a rule set which will come into play only in the event that the rail lines become operational. And in that regard, in my view, a definition of what an operational rail line was needed to be formulated, because clearly it's quite a bespoke provision and you couldn't expect the plan to already have covered that. So when I prepared this definition, I had in mind regular scheduled services, things that occur on a planned basis rather than smaller activities. And I'm thinking there are various places across the country where groups operate steam train excursions or occasional train related activities on lines. There's one in Rotorua as well. So if the panel has suggestions on that or council staff have suggestions on that, we could discuss that further. Turning now to noise policy 2. My primary amendment to this was to ensure that rail is included in policy 2. But when I was looking at the drafting of it, I felt there could be some readability amendments so that the items which have specific noise controls proposed, and obviously there's mixed use, light industrial zone, then the air noise boundary and the state highway and rail, were grouped together in subclause 1 rather than across 2 and 3. So got those there. But the key issue there is that rail is included in policy 2, and further down under the item Roman numeral 3, that not only are acoustic mitigation provisions implemented, but they are maintained also effectively to ensure that any mitigation they provide continues on an ongoing basis. Now we'll return to noise S5. I might, you'll see there on the left-hand column that in the red text here, we've got 100 metres of a operational rail line. That is the method which would apply the operational rail line rule and trigger S5. The changes on the right-hand side for the matters of discretion, in my evidence, I made a fairly detailed assessment, which I won't go over now, because I'm sure you've read, which indicates why I prefer a more simplified set of matters of discretion. The other key change for S5 is a little bit further down on the following page, on page 16, which is, excuse me, you'll see there, partway down the page, there are two ORs in capital letters, and one is followed by a B and a C. Both of those relate to rail. Both of those items are what I would describe as alternative compliance pathways. So either, if the operational rail line is triggered, either you provide the acoustic mitigation to achieve STEP levels, and I'll come back to that, or B, there is a blockage from line of sight from the rail in very simple terms, or C, the building has been constructed in accordance with a schedule, which is further down and called Schedule Z. So there is opportunities there to provide different ways of meeting the permitted activity rule status, and that's what's explained in B or C. Under C, you'll see Table 1. That relates to the first compliance pathway that says if there's an operational rail line and you're within 100 metres of it, the buildings will be designed to meet the standards, the specified maximum internal noise levels. Now, I do apologise, the table is quite small. It was difficult to fit inside the formatting there. But what Table 1 does is for the noise sensitive activities, it gives a variable range of internal noise levels that have to be met depending on the sensitivity of the activity. And you'll see there they range from 35 to 45, health clinics being 45, and for example, residential being 35. This provides a nuanced approach to trying to match the sensitivity of the activity with the level of protection which is proposed to be required. So whilst it looks quite complicated, it's an effort to make sure that the response meets manages the effect in an appropriate manner. Just scrolling a bit further down, you'll see on page 17 there are some ventilation requirements there which are included. And then going to page 18 is the construction schedule. That is compliance pathway C, which I alluded to further up. That says if you build your building like this, you'll be deemed to comply. Got that covered off there. Further down on the bottom of page 18 and top of page 19 is the explanatory text that I have proposed for the alert layer for noise and vibration. And that is, as Mr. Pates has described, and I agree, it is the layer that says if the rail becomes operational, there could be noise or vibration effects in these areas. There are no rules associated with this. That is why it is simply a paragraph which sits in the overview section of the provisions. That is probably all I was going to cover today in terms of that, but of course I would be very happy to answer any questions. I do appreciate the changes to S5 look fairly comprehensive, but they are with a view to getting a good outcome, which provides different opportunities for parties to utilise.
Yeah, Mr. Watson. Yeah, thanks, Kathy. That S5 is pretty comprehensive. Just looking at those RDA criteria that you've got on the right-hand column, and I'm looking at page 16, there's 4 of them, 1, 2, 3, and 4. I mean, those RDA criteria seem to get more general as the process of the district plan goes on. I just wondered how you'd apply, or how the planning officer would apply assessment criteria number 4, which reads the outcome of any consultation with Kiwi Rail. Is
Yes.
that an assessment criteria?
It's an excellent question. It's obviously requiring notification of particular parties is not necessary. or indeed allowed in the plan provisions under the RMA. The consultation section is aimed to provide council officers and applicants with up-to-date information about what is planned or proposed for the particular section of rail line. It could address things like train frequency, future expansion or not of the area. I think it's suitable for an assessment criteria. It's been adopted in quite a range of other plans across the country in terms of a method of ensuring that suitable information is available and considered at the time the consent decision is made.
Yeah, that seems to be the defence of a lot of people answering questions. That's what's done in other district plans. Yeah, I suggest there might need to be a bit more than that sometimes. But yeah, no, I'm happy with what you had to say. Thanks.
Thank you. I think you might have heard a couple of my questions earlier on. So I'm also on page 15. First of all, the definitions, including hospitals, was one of my questions. And also marae and churches. And I wasn't sure what you mean by marae. Can you tell me what that means?
Not my field of expertise in terms of what that encompasses in terms of a lot of detail, but my understanding marae can accommodate sleeping spaces and also spaces where there could be gatherings for speaking and areas which would benefit for quieter internal noise levels being achieved.
Would that include like wharekai, or we have a definition under our plan? Is that consistent with what you're proposing? And also place of worship, I wasn't.
Yes, now if you just bear with me a moment. Sorry, I'm paying attention. I'm working off two screens here. Sorry, I appreciate I'm not looking at you. I'm just going back through my evidence where I'm pretty sure I have addressed that. Right, so I'm just looking at page 11. Sorry, top of page 10, bottom of page 10, top of page 11, which sets out KiwiRail's original submission. And as you have pointed out, the bottom 2 points talk about congregation with any place of worship and activity in relation to marae. Now, in my paragraph 715, item C, I've concluded that the amendment which KiwiRail sought relative to, excuse me, congregations in marae isn't required. And the reason for that is because it's already captured within the existing plan definition, as it was notified, of community facilities. And you'll see there on the second to bottom line of my paragraph C, the community facilities definition includes buildings used for, and I'll skip along there, cultural, about middle and worship purposes. So in my view, the council's version of the noise sensitive activities, which includes community facilities, would already capture cultural buildings or buildings for worship purpose. So I think the circular answer there is yes, it would capture whatever council has considered as a building used for cultural purposes or for worship purposes.
We have in previous hearings had discussions of the definition of marae and different buildings within that complex. I'll also I just want to clarify from staff as well and the right reply about that aspect there in C, and the definition of community facilities where it says buildings used for cultural purposes, what that would encompass or not in terms of the marae. Would the wharekai be included, or is it just the wharenui? Or I think clarity around that would be helpful. The other question I had around the definition was the word regular. The word regular under the definition of operational rail line. It means a rail line which has regular scheduled passenger or freight services. I wasn't sure what that meant.
Regular would have its plain English meaning, in my view, in that regard. I'm not proposing it to ascribe it anything special. So I'd suggest you as repeated often, has a pattern which is recognisable.
You took the word regular out of the definition, you don't lose anything by it, do you?
No, I was with the use of regular, I was trying to convey, because the scheduled passenger service might happen once a month. I was trying to convey a high level of frequency, but regular doesn't actually do that in that degree of specificity.
The reason I asked that is I wasn't sure what the trigger was for council to, in the building department, for example, to implement this. So if I understand it's been detailed here, it will go into LIM, so purchasers will be aware in the alert layer. But actually, when people would say, oh, I've seen one train, it might be regular now, I might need to get my acoustic engineer ready for my house. Or, you know, how would the building department know that through the PIM process that, hey, these guys need now to get an acoustic engineer or not?
Yeah, that's a really good question, and I would suggest that it would require some form of notification from KiwiRail to council to say the line is open. We're, you know, proposing 1, 2, 3, 5 trains a day or whatever it's going to be, in terms of kicking that off to make sure that council as a whole was aware and not leave that onus to sit with individual applicants.
I think that's a practical suggestion. I just wasn't sure how it would work and what notice periods council might be given in that regard. So it's operationally can be given effect to.
Yes, in that regard, I appreciate Ms. Grillenton Hancock isn't here today, but we did around this exact topic. There is a rail line elsewhere in New Zealand, which I understand is in currently not used a great deal, if at all, and there is a discussion underway with a potential user. But those discussions, as you can appreciate, firstly they're confidential, but also they take quite a long time to come to fruition, to have that the rail activity reenacted, if indeed that's the outcome of this discussion. So there would be quite a lead in time for KiwiRail to say the line is now open. So I expect there would be quite a time frame to firstly get to a position where the line would be reopened, ensure it's maintained and suitable for that purpose, and then actually start running the trains. So there would be, it's not an overnight thing to happen. And as Mr. Pates and Dr. Charles have indicated, for that to happen, there would need to be a significant, excuse me, a significant end user to reactivate the line.
The last question I had was about this, the changes to noise S5, and one of the ORs is a noise barrier. So under B, and then it talks about completely blocking line of sight from parts of doors and windows to all points 3.8 meters above the railway tracks. So I guess it's different, you know, in implementation, you don't use the rail every day to get around like you would with a road, you know, from residents that live adjacent to a road that creates noise. So if someone built a house and, you know, it was within the 100 meters, you, based on this here, you're saying that if they built the noise barrier fence to block the house from the line, that they wouldn't need a resource consent, or they would just show compliance with this B. Is that the intention of that there? So essentially this rule says if you do this fence, then you don't need a resource consent, just provide that to the council and give a letter from KiwiRail.
Yes, although I would caveat that by two things. One is I'll invite Dr. Charles to add anything once I am finished. Obviously, the building needs to be at least 50 metres from the rail network. Yes. And the 3.8 metres, you can't just build a fence that high without relevant consent. It's really designed more to cater where there are existing things or items which provide that on a permanent basis, and also for topography as well. Dr. Charles, would you have anything you'd like to add to that?
You just took the words out of my mouth. The origins of that were not so much where the applicant comes along and builds a big wall. It's more where the rail's in a cutting, or there's a row of existing buildings that are screening the rail. Because to screen that 3.8 meters, that's a massive noise barrier. So it's not expected that an applicant, under this rule they could, that has Ms Heatherthwaite said there might be other constraints, but the provision's more where there's terrain screening or existing building screening.
Yeah, that was my question. 3.8 meters is huge.
Yes.
Yeah, I'm not sure why it's been proposed as a practical solution, but
Quite often you will have terrain screening or screening by existing buildings. So you're right that it would only be in a dense urban area that you may actually contemplate building such a massive noise barrier. But in other areas, you'll often find the terrain will cut off line of sight.
I don't think we've got any more questions. Is there any points of clarification from the staff? Although I did pick up earlier on that Kiwi Rail obviously interested in focusing with the council staff. We see that as a great benefit to us, obviously. So we would encourage you to do that, both parties, but I'll leave that up to you to sort out, because the staff have to report back to us in 4 weeks. If they needed an extension for that, I don't think the panel will have any issues with that, but so it'd be good, any points of clarification?
Yeah, I do, sir. I just would appreciate just some clarification around some of the mechanisms around, in particular, the alert layer, and I guess my interpretation of the mechanism that's been proposed essentially results in buildings being built in the interim between when the railway is declared operative, for a better word. So they can be built without control in the interim, is that correct?
Yes, that's correct.
And I just wasn't sure whether there was any requirement after that on any party to mitigate effects that will arise from the not the re-establishment, but the reoperation of, albeit a designated railway.
So I think I've understood the question is that today, for example, someone could build a house within 100 metres of a rail line and provide no mitigation, even if they, the alert layer's there and they are aware of it, and then the rail line might become operative, and there would be no retrospective obligation on that party to provide any mitigation of any sort. Is that the question?
Yeah.
Yeah.
Yes.
Yes, that is correct. It is not proposed to require people to mitigate an effect until the line is operational.
But the overlay would tell them that the railway might come operational, and then it's up to them.
Yes,
whether they decide to do it. Yeah. So
that is correct, sir.
Buyer beware.
Yes, sir.
Yeah, and I guess, I think the point is well made that the effect would obviously occur on that person. They would be in an uninsulated house. The rail line starts up again. They would feel those effects. But KeyRail's taken the pragmatic position that we can't retrospectively ask people to retrofit their houses after the fact. And I think it is as you've said quite succinctly, it is a buyer beware situation. The alert layer places them on notice that they are in that close proximity, and that it could become operational, but we only focused on people going forward once it becomes operative from that kind of pragmatic perspective.
Anything else, Mr. Whittle?
Yes, Mr. Chair, if you mind. And I guess my interpretation today, from what I've heard, is that it refers to, the reference has been made to the line. Whether that means the entire length of the line or just the operational length, could that be all or part, for example, of the line, as opposed to the whole line, if not all of it's being utilised?
I would expect, yes, there may be some circumstances where only part of the line is brought into play, and I believe one of the commissioners has pointed out the existence of a cycle path over part of the line. So it may be that the line only runs to the end of the cycle path, for example.
And it could be that we clarify the mechanism so that it only applies to, it's not that if part of the line becomes operational, that the overlay applies to all of the line, that it only applies to that section of the line that is operational. And I think that's probably not clearly reflected at the moment, but I agree that the same premise would apply if you're in the cycle trail part of the line and that isn't operational, it's still operating as a cycleway. The basis on which we've put this forward is we are not trying to impose controls where there are no trains running near you. And so I think that could be clarified.
Thank you, Mr. Chair. And one last one.
That's all right.
Thank you. And forgive me if this was explained when I was out of the room. What happens when the use of the line ceases again?
Excellent question.
I think the same basis is, I think I'd be hypocritical if I said they should still apply. I think if we're saying that these controls should be triggered when the line is operational, they probably are triggered while the line is operational, when it's sort of that live nature that is the triggering. You know, I guess it's sort of pros and cons, isn't it? Because to the point earlier about retrospective application, if you do have houses that are built in that interim period that aren't putting in acoustic insulation, they are in a very vulnerable position as soon as the line does become operational. And so I guess from trying to sort of mitigate health and safety effects on, or health and amenity effects on those people, I think once it's triggered, I would probably want to keep it up and running. But you know, the basis on which we are proposing this is, you know, we want to be pragmatic. I guess one suggestion that we could take away is you will have seen in the evidence and the legal submission that this was based on the approach that was taken in Whakatane. And what we haven't been able to quite nut out pre this hearing is how the process worked there. And the Whakatane line is active in terms of forestry coming from Kawerau. And so there will have been a process in terms of Key Road telling council that the line is being used. There are other mothballed lines in the Whakatane district that aren't operational. And so we could provide more clarity on that actual pragmatic process on the ground. How did Key Road talk to the Whakatane council, and what that looks like from a pragmatic perspective in terms of the discussions with the council staff going forward.
Thank you, Mr. Chair. Those were mine.
Okay.
I do have something which I think is worth asking.
Yeah.
It is quite long, and you'll have to bear with me as I explain my rationale for the question.
So who was it directed to?
It's directed to you, but I think it's important that KiwiRail hear it, and I think they might need to consider it as well. Firstly, I just start by pointing out that the structure of the rule as it's written doesn't actually require rail to seek, person building within the rail to seek an acoustic design certificate. And that's really a wording situation, which I'm sure we'll address in the right of reply. But the intention, as I understand these road and rail rules, are that if you are within a noise control boundary, that an acoustic design certificate is sought, so that the facade requirements can be determined, so that certainty can be had that the internal design noise levels are met. Now, for road noise, the requirement is that an acoustic design certificate is provided, and that acoustician, I think, uses their judgment as to how they determine what level of road noise the dwelling will receive. That acoustic engineer would do that by one of two methods. They would calculate the noise based on the road traffic volume, or they'd visit the site and perform noise measurement, possibly some combination of both. But for rail, what KiwiRail is proposing is that isn't an option. They're proposing that a general noise level of 70 decibels at 12 meters is used as the design basis. You've heard from Dr. Charles that he believes that that's appropriate for rail lines. My point is that for the northern rail line out of Whangarei, my measurements were that the noise level from that rail line were appreciably significantly lower than this approach. So what this does is that it may not necessarily take a conservative approach, but it could do. And I wonder if possibly, like roads, there might be the opportunity to, if the rail line does become operational, to then require that the sound insulation assessment is instead based on the actual use of the rail line that actually occurs at that time, possibly with some allowance for future increase in movements, but that it would in fact be, there would be a mechanism such that the actual real noise could be assessed and could be responded to, rather than taking this generic and possibly conservative approach. Is that useful? Do you understand?
I understand what you're saying.
Yeah, so it's arguably introducing a more conservative control, providing greater scope for Kiwi Rail that possibly they need.
Well, I think for Kiwi Rail, their concern might be that the rail line starts and one train goes up with a few carriages to, say, the Morewa Meatworks, and then the design that is based on that isn't sufficient to cover, say, 2 years' time when heavy logging trucks start using it. But we've heard from Kiwi Rail that they think that there might be an opportunity to notify councils that the rail line might be used in such a way. There's a lot of uncertainty here, as we'll be aware. It just seems to me that there should be an opportunity for the reality of the circumstance to be used in the design of dwellings, possibly rather than just a simple conservative approach, which may not necessarily ever reflect the reality of their rail line.
Nothing else? Thank you.
That's it.
Tim, have you got something else?
No.
So, Mr. Childs, do you want to?
If it's appropriate, I'd like to comment on Mr. Ibbetson's question. So I acknowledge the issues Mr. Ibbetson's raising. It's a imperfect situation. There's a fundamental difference between road and rail, and that difference is why there's a different approach proposed. So with road, the traffic and the noise levels tend to be reasonably steady from year to year, from decade to decade. We talked before about speed limits changing from 100 to 80, and the noise level might change by 1 or 2 decibels. But by and large, it's fairly steady changes. So you make an assessment of the road noise here today. You add the rule requires you to put a bit of allowance for change, and then you can design appropriately to that. And so that works for road. It doesn't work for rail because rail traffic changes significantly. And the example of the North Auckland line is the perfect example. So Mr. Ibbetson referred to, he's taken measurements where there's a little shunt service that goes up to the dairy factory and comes back. But then that's quite different to a mainline freight service that potentially could operate on the line in future. There'll be different locomotives, different rolling stock and so forth. And so using the train service that happens to be operating on that piece of line today or tomorrow is not an appropriate indicator of what might operate on that line, certainly over the lifespan of the house, which is going to be there for 50, 100 years. But even just with the lifespan of the plan over 10 years, the rail noise today may be a poor representation of what noise might be expected over the life of the plan. And so that's the I agree with Mr. Ibbetson that it sort of does lead to a slightly awkward situation, and it is different from road, but that's trying to address the realities of the way rail lines work. And there's Kiwi Rail win a contract to shift whatever freight it is from A to B, and so you'll have a certain type of train, a certain type of service that might start, that might stop, and so the basing things on what's happening here and now is not a sound basis for a house that's going to be there for over the long term.
Thank you, Mr. Chair. Ms. Gunnell, unless you've got anything else, we haven't got any further questions.
No, I think that's all from the team here. So thank you very much for your time. We really appreciate it, and have a great afternoon.
Okay, and as I said, we're quite happy for the parties to caucus between you and the council staff. If that's what we choose to do, it would make our job easier, and it might make the council staff's job easier in the long run. Okay.
Thank you, sir. We'll be in touch with the hearing administrator to make those connections.
Thank you very much. Have a great day.
Thank you.
Very much.
So we have 10 minutes until Tony Michelle.
We'll have a quick break.
Right, quick toilet break. I'm going to leave us recording, but I will mute and turn the camera.
Next we've got
Good seeing you here.
Yeah, exactly.
Thank you very much. Good afternoon. Is it afternoon?
Yes.
Now we've got the New Zealand Agricultural Aviation Association, Tony Michelle. My name is Bill Smith. I'm the chair of the hearing. On my right, we've got Councillor Corey, who's a commissioner as well, accredited commissioner. We've got Mr. Watson on my left, who's we've been appointed to hear the submission to this suite of topics and make a recommendation to the council in due course. We've read your evidence, so you can summarise it or you can whatever you want to do. And we will ask some questions, and we may ask the staff if there's any points of clarification result of what you said. In about 4 weeks' time, we'll get a written reply from the officers what they've heard, and that will go on the council's website, and you'll get notified it's there, so you can see what they've responded to and what regards to the topics that you're involved in, and possibly what you've said. So, have you got any questions before you start?
No.
All right, where you go then.
Okay, well, thank you very much. Given that you've read the statement, I'll just cover off some of the highlights, perhaps. So I am Tony Michelle. I'm the Executive Officer of the New Zealand Agricultural Aviation Association. We're one of 6 divisions of Aviation New Zealand. The 42A report rejects the inclusion of a new objective to ensure that lawfully established and permitted noise generating activities can continue to function and operate. This is sought to ensure that the plan recognises the importance of protecting these activities. The 42A writer concludes that the concept of existing use rights under the RMA already provides for this. However, we contend that section 10.2 of the RMA determines that existing use rights will lapse when the activity has ceased for a period exceeding 12 months. So currently we believe that there is probably existing rural airstrips and helicopter landing areas within the district that will have been unused for a period of greater than 12 months. So existing use rights may well lapse. The 42A report recommends that an additional exemption note be added that states, and I quote, agricultural aviation, if compliance can be achieved with temporary activity rule number to be determined, unquote. We do not support that. We agree that a separate rule should provide for agricultural aviation activities. However, we disagree that this should be accomplished through temporary activity rules. Agricultural aviation activities are intermittent, occur for short periods of time, but are carried out on an ongoing seasonal basis. Agricultural aviation activities are a subset of primary production activities, and we think they should be included as part of primary production activities, not a distinct temporary activity rule. The zone framework descriptions in the MPS for the general rural zone and the rural production zone clearly identify activities that support primary production activities. The descriptions do not refer to temporary activities. We seek a specific rule for agricultural aviation activities to ensure that they are adequately provided for in the plan, recognising the importance of the activities to support primary production and conservation activities. Other district plans have provided for agricultural aviation activities as a permitted activity through the noise or zone rules, and they are listed in the statement. Interesting to note that apart from Westland Combined, TTPP and the Gore PDP, all other districts listed in 2.7 of this document provide for the use of rural airstrips and helicopter landing areas for agricultural aviation activities without any hour or daily limitations. Further, the 42A report rejection of the relief sought by NZAAA and Hort New Zealand to noise S4 by noting that the standards do not apply to helicopter agricultural aviation activities is not supported. So in summary, the decisions we seek is to add an objective as sought that lawfully established and permitted noise generating activities can continue to function and operate, accept a new definition of agricultural aviation activities as recommended, add a new rule as sought for the noise rules for agricultural aviation activities, and amend the noise S4 note as sought by adding that NZS 6807 does not apply to agricultural aviation. Happy to take any questions.
NZS 6807, can you just remind us which standard that is?
That's a helicopter landing.
That is standard. So those other district plans that you mentioned there that provided provisions along the lines of what you're seeking, are those ones that you've been involved with, or just ones the association have been involved with?
The ones that I've been involved in and the association have been involved in. One of the challenges I put to councils is we understand that sometimes people want to know how long a piece of string is and to have in limits. And we're on board with the 30-day or 315-hour limitation, but in practice, how are you going to actually monitor that, investigate it, ensure that there's compliance to it? And one of the other things that we're adamant is that the landholder should be responsible for recording that, because if I'm a helicopter operator and I go and work on a property, I don't know who's been there previously, and I don't know who's coming afterwards. Only the landholder can know that. So, and I've just been to the regional council yesterday to talk about some of the challenges with the regional plan in terms of conditions of application for agrochemicals and fertilizers. And one of the big challenges they have is that in that plan, it says that farmers will have a spray plan. Now, our operators are getting issued abatement notices because they're going and working for farmers who don't have spray plans, and they don't know that they had to have a spray plan. So, you know, getting those comms around. So these people are busy. So if you've got a permitted activity rule like this and you're really drilling down into some nitty gritty, this is something that's not going to be front of mind for a farmer with an airstrip or who uses helicopter systems, helicopter operators. So therefore, what does that mean for your staff when there's a complaint and they have to go along and investigate this and then ultimately take it to some sort of conclusion? And I often think that councils are actually making the log for your own back, because at the end of the day, no farmer is going to get an aeroplane that's going to work there for 30 days continuously, or a helicopter that will work there for 60 days continuously, or more than 315 hours, because they can't afford it. Yes. I mean, you know, the straight economics of farming will determine that, or even the forestry area. So as I say, you know, just we can live with it, we can work with it, but is it necessary?
How does it get policed by enforced?
Yeah.
If you turn up a helicopter pilot, how long have you been here? I've been here 1 hour. There might have been 10 other helicopter pilots there long before, you know, it didn't.
Yeah.
I understand where you come from. Okay.
Yes, it was just about the use of drones, and I can see in your original submission and also as evidence here that the term unmanned aerial vehicles, is that the technical name for drones? Because I see in your original definition you use the word future-proofs the plan, or sorry, it's on an angle. The attachment here for aerial vehicles or drones.
And that's very deliberate, because at the moment, you know, drone technology, I think probably 60-litre drones for agricultural spraying are the biggest that are operating in New Zealand currently. There is a 250-litre one that is due here imminently. That same company is building a 500-litre capacity drone in the United States. We will likely see some of them here within the next 2 years. There's a company in the States that has converted a Robinson R44 helicopter into an autonomous remotely controlled aircraft. So that's a UAV. So the perception that drones might not be a problem because they're small and have small effects, well, actually the capacity is building, and the plant that we will see in the very near future will have very similar effects to common manned aircraft that we have now.
because I had a supplementary question about drones, and I think you put up a point about the 60 litres now, the ones that yeah 250 litres. It talks here under your definition about agricultural aviation activities, and it talks here about stock management, application of fertilizer, agri-chemicals, and vertebrate toxic agents. I wasn't sure when you talked about for primary production activities if that included the scope of mapping and I guess getting more technology use for the primary sector, which I would anticipate to happen over the next year, and normalise particularly through farm plans. Just feedback from yourself for that question about the definition. And I guess we'll start.
Yeah, that's an interesting one. I hadn't thought along those lines. I mean, I would think of mapping as in mapping a farm or mapping a crop. I wouldn't think of that as of mapping an area for hydrographical surveys or something like that, or mapping residential or lifestyle areas or anything like that. The mapping would be associated with primary production.
And so you think that definition there, you know, like using drones for mapping aerial, basically providing information to use for technology is covered under primary production activity.
And conservation activities as well.
Yeah, so you think that's within the scope. Okay, thank you.
I'd just be interested whether the office has had any view on the suggestion or at 3.1 about adding an objective about lawfully established and permitted noise generating activities to new function and operator. Isn't that just a matter of fact? I think the existing use argument is perhaps one that's been introduced by the reporting officer.
No.
I mean, if there's a helicopter landing area and it's not used for 12 months, that doesn't mean it can't be used.
But I would suggest that the scope of the objective is very broad and applies across the plan to all activities. And that scope is far too broad, particularly in relation to noise, where there's multiple examples of where the receiving environment changes, for example. And this is not particularly relating to agricultural aviation activities, this is in general. So as proposed, it's far too broad to be useful or helpful, and essentially it will create a problem that Section 16 has to resolve, right? So putting that aside, the provisions are intended to, there will be a mix of sites used, right, across the district. Some will be historical sites, some will be new sites. The provisions are intended to be, even if there is a loss of existing use rights, which is again a matter of fact, to be able to provide 30 days worth at a minimum. It's not intended that the provisions really are, it depends on there's quite a broad variety of rural environments, right? They're not all the same. So it provides an ability to check in to see, and I think while they've requested to be exempt from the helicopter standard, the use is probably, we've also heard today or this yesterday, but this week, similar use talked about from people who have this, what we call this, those developments, the comprehensive subdivision developments, the Benson Farm type crowd, and would have probably similar effects. It's a national standard, I guess, for a reason. I wonder if
I mean, I think, yeah, just if I can interrupt you, I think what you're saying is what I'd anticipate you'd say. And I guess the question that follows on from that is, does the submit actually need the objective if they get the new definition of agricultural aviation activities?
Yeah.
I mean, I guess people are looking to help the submitter because they recognise the value of the service they provide. We don't want to lose them in the generics of a district plan.
Agreed. Yeah, look, the idea is to be, to a degree, enabling. I'd be interested to understand how many rural either helipads or would be used in excess of, or any location outside, it doesn't have to be a helipad, it applies more generally, would be used more than 30 times a year. The flight time might be a little bit more of a vague, difficult to answer, but it seems to me, I mean, I think that's probably.
Great, so I could give some context around that. Probably in the helicopter world, it wouldn't be an issue. In the fixed wing world, where they're top dressing and you've got a hub airstrip that might be servicing a dozen farms, that's where it could become problematic. And the reason that we asked for the 315 hours is because what happens if the aeroplane goes out there and does 2 loads and the wind gets up, and that then constitutes a day. So now there's 29 days to use that strip. And what we don't want is pilots going out onto airstrips and thinking, look, we got 10 days left to use this airstrip. The wind's now got up, but I need to keep going here because otherwise we're not going to be able to service all our clients, and it becomes a flight safety issue. And we don't want pilots being out there with those pressures sitting behind them. But we think that at 315 hours, that's operating hours, will adequately provide for that without putting those pressures onto the pilots. That's the reason we don't like that 30-day thing, because land there once and take off, you've lost that day.
To the chair, absolutely. But what I'm perhaps hearing though is that those sorts of high use airstrips would probably not. Yeah.
Because they get being used regularly, it's the ones that aren't used regularly that are going to get caught.
Acknowledging though, like in addition, like there are seasonal factors, but I would consider that, you know, there might be years where the return doesn't justify top dressing, for example. But I would imagine that, again, you could be flexible in your interpretation to say that's part of the normal use of that airstrip. It doesn't necessarily mean you use it every day or every year. That's not to say you'll use it. The character, it talks about character, use, and intensity. And if that's a seasonal type activity and seasonal for pastoral farmers, for example, as more than 12 months in terms of sort of more related to the economic cycle, then we could be reasonably flexible about how we will interpret that.
Well, that's really topical in terms of how we sit here now, because the top dressing activity from the CAA stats is down 52% compared to 2022. So that, you know, that's why we say in this evidence there will be strips and there will be sites where helicopters have been using that haven't been used for a greater period than 12 months. Farmers haven't got any money, spending any money. That's the bottom line.
If we decided to adopt your definition of accepting you agricultural aviation activities, and then your objective, we could, I'm just talking out loud, I'm saying we are, your objective could be worded locally established, permitted noise generating agricultural aviation activities can continue to function and operate. So you add it in there so it doesn't cover everything else. But I'm just saying, I'm just talking out loud at the moment. So yeah, you've got the definition of agricultural aviation activities, and you put it in that objective that you're asking for. So it only covers that one-off thing. But I'm just talking out loud at the moment.
And we acknowledge that you know that the intent is to be enabling here. Absolutely. You know, we haven't got a gripe at all. What we're trying to do is make sure that there's not something a bit further down the track that becomes problematic.
All right, thank you very much.
So easy. Thank you very much.
Safe journey home when you're heading there.
Everybody there?
In Chicago.
Oh, in Chicago.
Yeah.
Oh, you're going there shortly?
Yes, Tiny Institute Conference.
Yeah, you make sure you bring sunshine with you.
I will.
We have seen nothing but rain for 3 months.
They've been trying to bring that for 300 years, haven't they? Like it's be a big ask.
It's been one of the wettest springs that I can ever remember, and we've had 20 helicopters in the Southland Basin for the last 3 months spreading fertiliser because the bulky trucks can't get on, the aeroplanes can't get into airstrips.
Did you have a dry winter though?
I did have dry winter.
Yeah, so I live in Whakaua and winter was very dry, but spring has been wetter.
Yeah.
So I get you.
You're going to have about 300 planners down in Invercargill. They're all going to bring a district plan down apparently.
Stop the recording.
Oh, thank you.
Give me the